Yep.
All right, good morning, everyone.
Good morning.
Get started. This is Franco Barile from Barile. That's correct. And he's going to give you a lot of information. Let me just tell you something. I came to need and used his company, and they did a fabulous job. So, hopefully, you want to listen.
I appreciate that. So Franco Barile again, attorney in Cleveland, co-owner of Barile, partners down in Loveland, Ohio, which I'm sure some of you know, south of Columbus here. Been doing this for about 15 years, and this is auto side, auto efficiencies, reflective work, really anything that involves a car, we'll probably soon on. One of the things we don't do is on the dealer side, which is any type of litigation that happens within the dealer and the customer. We really work on the finance side. So dealers are financing their own loans, or if a finance company is obviously financing the loan, that's where we jump in and we assist in collecting on that debt. So just a little background on myself. So today what we're going to talk about is just understanding the ways to collect delinquent accounts. And when you think about a delinquent account, it's every account that goes delinquent, no matter what happens. You were talking with somebody earlier today about the car burning on fire and it's gone. Now what do you do? Well, you can still go after that specific borrower. You still have the debt that's owed. So any debt that's owed from getting out a loan or a lease, you can attempt to collect if it's worth it. So today we're just going to understand some of those ways. Wrong way. All right, so I consider them the 5 different scenarios. So that first scenario is the replevin process. That's where the borrower defaulted on payments and refuses to return the vehicle. So a pretty common defaulted idea. So the car's still out there. You kind of know where the car is. Maybe you know where the borrower is. And you're thinking, how do I get this car? At the end of the day, you really want to collect, you at least want to get that car back, sell it, and apply some of those proceeds to what's due and owing. So on the replevin process side, obviously you've done this before, you're recovering cars, you send out your own repo agent, and maybe it's stuck behind a garage or a fence. So we'll kind of discuss number 1 first. The second scenario is a vehicle is towed by police or a government. So again, you're not lost here. If the police have taken over a car or whatever traffic accident or traffic incident happened, crime scene, they'll impound that car, maybe send you notice. As soon as you find out about that impound, that's when you have to start working really fast. So we'll kind of go through that scenario. That third scenario is the vehicle's towed off private property. A little different ways of how to secure the vehicle once it's been taken off private property. So between 2 and 3, you're just looking at whether the police impounded that car or a private company towed that car off the lot. That fourth scenario is the vehicle stuck at a repair shop. We've seen a lot of this in the past 10 to 15 years, and when it's stuck at a repair shop, it gets a little hairy. But I will tell you right now, while it's not the easiest, legally speaking, it is one of the easiest. It's the most protected that you can get as a lien holder on a vehicle. Fifth scenario, the vehicle's been repossessed. Now what? Is it worth pursuing a deficiency balance? If you find out that the borrower is employed or still employed or is employable, and you've got a car and you just repoed it, you decide on whether you're going to pursue a deficiency balance. And there's certain things you can go through, kind of a checklist of items. Is it worth it? Is it worth going through that process of selling it at a public auction, securing a deficiency balance, and then trying to collect on the deficiency balance? So that's that fifth scenario. So the replevin process. Most courts continue to allow a locksmith order. All that locksmith order is if a car is stuck behind a garage or a locked fence, because if it isn't, your repo companies are good enough to find these cars and take them. It's really when they're stuck. If you can't find the borrower or the car, the replevin process is not the best, because then you still have to go through the court system and you still have to get them served. That's tough. So really, obviously, you all rely on, you do rely on your repo agents. They're go get the car. If they're stuck behind a garage and you know that's where the car is, that's where this works. And courts do require a bond that's worth twice the value of the vehicle. If the vehicle's $20,000, you need a $40,000 bond. You don't have to pay $40,000. You have to pay somewhere in the $800-900 range to secure that bond. That bond is for a borrower to come out and say this was a wrongful repossession, wrongful replevin. I've seen that defense. It never works on the borrower side. You probably have a lien on that car. You are the lien holder, and you are rightfully entitled to repossess that car through the court system. Nothing else left. Unless the borrower did not default, that could be an argument. It still doesn't affect that bond. So it's not as scary as you think having that bond. Once things get filed into the court system, there's a hearing. The attorneys appear at the hearing, and that's where we attempt to secure the locksmith order. And everything's done by the law firm that gets submitted to the court. So within, give about 20, 30 days from that complaint being filed, you have a hearing, you're in front of the judge, and most of the time you get an order signed by the judge. You're in some courts sometimes that maybe not as creditor friendly. So I'm from Cleveland. I'm from the land of debtor friendly courts. They just don't want to see these filings go through. They don't want their sheriff's department to go out and secure a car when they should be going out fighting crime, which that argument doesn't work. You know, this is part of the sheriff's job, part of their position is to take vehicles from a court order. So again, the process is still available. While it's a little pricey on the bond side, the process still does work. Once you do secure that order from the court, once we secure the order from the court, we then have to kind of fight with the sheriff to go and get that car. That's one of the big things too, is a lot of sheriffs are starting to finally do that again, starting to go out and execute on these orders during COVID. 2020, 2021, even 22, sheriffs just said, nope, we're not going out. So we're stuck with this many orders sitting there waiting for the sheriff to go out. Nothing you can do about it. Nowadays, it's kind of loosened up a little bit, and the sheriff's starting to go out again. That's when it really takes the time for the law firm and you as a client to be ready, because the sheriff can call you today for an execution tomorrow. So obviously you have to get your own agent, you have to make sure you meet the sheriff there, but still, at least you've got an order, you've got a place, you know where it is, to make that attempt. And if it has been recovered, and you're successful, or you're unsuccessful, it doesn't really make a difference. There's always a second count in the complaint going for money, and you end up getting a judgment for the balance. So whether it's the balance of the car after sale, or the balance where you can't get the car, you can still then attempt to collect after. Yeah.
When the sheriff's assistant, what parts do they do? Just keep peace, basically?
No, they will actually allow the locksmith to come along, and if the borrower doesn't let you into the garage or into the locked area, they will actually remove the
So we
borrower.
know it's in the garage.
They go to the garage, they bring the locksmith, you could have the borrower coming in. So when you talk about breach of peace, that's why you go to court, because you're going to breach the peace when you go to court. And the sheriff's okay with that. That's why the sheriff's there.
Because our local area, our sheriff, the only thing we're going to do is make sure it's all done.
Yeah, they have the same.
You know, but if we know that it's behind locked doors, we know we've had multiple vehicles in garages, we've had Harley Davidson setting us in the front living room. And so everything you can see it through the window.
Well, and it's the key is knowing a little more of that information. So if the law firm knows it's in the house, we also do rent to own on personal property where sheriffs are breaking doors down. So it's still there. You have to ask for your order though, that it's in an interior location. And then once you do, they have to knock and announce. Once you knock and announce, if nobody's there, the locksmith's allowed to go in and unlock that door. If somebody's there and it's a fight, the sheriff has the ability to stop that. And then really, you want those cases where they're not home. And it's in the garage or it's in that locked facility, and the locksmith goes in and assists to get you in and out of it quickly. But this is reason for treaties.
What the court system, if like people pay some money, the police, I mean, for instance, more work than the car.
Sometimes. That's what you
I
really have
don't
to
know where the car is, that GPS.
No. If you don't know where the car is, this is not your process. You don't want to waste your time. But again, you still have debt that's owed. You can just sue a borrower in court for money judgment, which is way more cheaper than this.
So wanna do a homework, you see.
Yeah, if you know your borrower, if you know that they might be employable, maybe your credit application, you've got a bank. We talk about that really at the end, on how to go after them, but that's really what you want to do. Again, this process you want to kind of hang on to for, if you know where that car is, and you maybe know it's locked up, or maybe they're driving around, and you just can't get them. This is still pretty good.
What do you have to do to emergency, true emergency, like this and
It's all fact-based. So you as a client would tell the law firm, this is why we think they're going. They're being evicted. Somebody told you that they're leaving town. It's all fact-driven. So when it comes to emergency orders, they're a little longer and they're more fact-specific, to where we can state, we believe they're going to leave and leave quickly. Some we have done where there was an eviction order set out for maybe in a couple of weeks. That's when the emergency is, that's when they get filed. Now those emergency orders, you can get an order really without service sometimes, without actually serving that borrower because you're worried they're going to leave. So it's okay, but you just have to, not even on your end, it's more the sheriff getting more concerned on those cases. They like the ones that go through the court system, the borrower is served with paperwork, they know what's coming. Now they have to come to court and say, no, I mean, they're wrong. They don't do that. I've done this for 15 years. They don't do that. They just come in and say, I'll make payments or do something. But majority of the time in the recovery process, nobody shows up. 99% of the times they're not there. They know they missed payments. They know they're keeping that car. They're waiting. That's just history. That's just what I've seen. Doesn't make it like it's standard, but this is typically what we see.
does this still work if they've already left the state, or you find out that they've left the state?
That's why it's important to have a law firm that does more than one state. So on our end, we do Ohio, Michigan, Kentucky, Indiana, Illinois. So if they're leaving anywhere in that area, we can sue them there. We don't dive into Pennsylvania, but if you find a Pennsylvania attorney, they can do that part. But really, anything, yeah, it's reasonable.
I know.
I always wondered about Pennsylvania. How that works. We have one west of Ohio and south. That's a good swath where they're crossing over, especially down that Cincinnati area. I mean, you could be living in Indiana and get your car in Ohio.
Right.
That's how close. Kentucky, same way. That's why it was very important for us as a firm to really have a stronghold in the area, because go where you want to go, that's fine. We'll just sue in that court. If they're going down to Tennessee or they're going out west, yeah, you'll find them.
To West Virginia also.
Shortly.
Because that would be argument would be Pennsylvania, West Virginia.
Yeah, West Virginia. There's another state too we're kind of looking into as well. That's, again, we look at the trends and we see where these things are happening. As far as repossessions, you probably know more than we do. It's on the rise, and we know more of that's coming up. Okay, vehicle towed by the police. That top line says the sheriff's required. That's what the statute says. What happens when they don't send you that notice? They're supposed to send you a notice that it's been impounded. A lot of times they don't send you that notice. Maybe you find out. As soon as you find out, you immediately call that governmental entity and say, where is it? What do I do? How do I get it out? How much do I owe you? We've had a couple where we've been able to talk to the police and say, look, you haven't sent any notices. You're supposed to by statute. Help us out. And they actually will sometimes call the tow company and say, let's be a little reasonable. Let's cut off some of these days of storage. You got to work with them. Otherwise, you will get a lot of police chiefs that come out and say, sorry, we didn't send you the notice.
Yep, I experienced that actually. And I called state highway patrol, went up the food chain, sent them the statute, and said, this is where you're the Ohio State Highway Patrol. You're violating Ohio Revised Code.
Yes.
And they basically told me the pound same.
And it's an unfortunate comment, but that's what it is.
You're charged, I mean, a governmental agency is in charge of enforcing Ohio Revised Code. Doesn't care that they know the Ohio Revised Code.
Now, you
What
just
is
gotta,
our recourse as a dealer? What is our recourse as a dealer to go after a policing agency, whether it's a state highway patrol, sheriff, to say, you've wronged me monetarily, I want money back?
they have immunity. And I'll give you one case in point. We had a client where they, for whatever reason, they submitted everything to the county for to get a certificate of title. And the county clerk forgot to note the title. All right, we actually said, let's give this one a try. Let's actually go after it, see what happens. We got another statute coming back at us saying, here's where the clerk has immunity. What happened is that borrower saw title, saw no lien, immediately flipped that, sold it, took the money, ran. The party that bought it has no notice of a lien, so they're a good faith buyer. Now the seller wasn't a good faith seller. So you can always go after the borrower. That's always, you can always do that. Getting your car is a little more difficult when it comes to police. I'm sure you tried the nice guy approach, and it just doesn't go anywhere. That is a major problem. Then we have one back here too.
Mr. City, the problem with the statute is just open-ended, it's only required to send a notice, but that can be 3 months, it can be 6 months.
Right.
Who knows when they're gonna get done?
Now they do, within the statute, there's time limits. I'm sorry.
Our advice goes 10 days.
Yeah, so they'll give you a time limit. They'll give you all kinds of, it's a really long, nice statute.
Our advice goes 10 days.
Yeah.
And it's not, and they say it's the tow truck company's responsibility. It's not, it's actually whoever impounds it.
It all depends, because some tow companies might need assistance for police, even on private property. You just have to worry about why it was towed. If it was towed traffic, if it was towed for a criminal investigation, sure, that's where that statute again. You have to know they towed the car, you have to call the wheel, you have to try. But the other side of it is, they could tow that car for a criminal investigation, and now they will not release it, even though you do know. All you need to go is go to court. All right? File a motion to release, you do need an attorney for that. A motion to release that seized vehicle, give them the statute, give them the affidavit, you go in, you take the car. Downside is you have to pay whatever's due, whatever it was. But police entities sometimes don't even charge storage. That's something that you can kind of negotiate with the impound company that impounded it on how to negotiate. That's the only thing you have to do for this type of case, is negotiation. You really don't have the court. What you have the court for is to release that car. So if it's stuck somewhere, sometimes you'll get a criminal investigation where it's part of the investigation, it's evidence. Our motion files, our motion sits, and you can't touch it.
We've always found the best way to handle that, because like you said, you really don't have any leg to stand on, is just to be as friendly as you can with all the major tow companies in your area.
Absolutely.
If you got to buy them a pizza once in a while or whatever.
Yeah, you can work with them, and also when it comes to the court system, you want to file that motion, file as quick as you can, at least get it on the record that you have a lien, it's been defaulted, you want that car. And then, if you really get a court system, unfortunate like Cleveland, you call the prosecutor. You say, how big is this case where you need this car? Sometimes it's like, no, this is the case. The case is the car. Okay, you have to wait. But a lot of times they will give you that car back. You start working around the prosecutor, start helping out. Lucky if it's an impound that you do know. Unlucky if it's one you do know on the other side where they're not doing a good job. While this is tough, the options are still there. You can still file with the court to get that car released. But beyond that, storage costs, it becomes difficult. So negotiate, work with them. You always work with the law firm to try to work further with a tow company or a police entity. Yes.
What's the longest it has been where the vehicle was part of the investigation for evidence that they won't release it?
Over a year. Yeah.
And then after that,
Then you can get it.
there's no reason for that not to be used.
Now, once it's being used for evidence, that's a strong hold. So what they do is they put a hold, they put a police hold at the impound lot. So if anybody comes to try to pay, they need an actual court order release. And that's where you get your order from a motion. Your motion sits there, you hold, you call the prosecutor once in a while, what's going on.
6 months so far, they're continuing that. I don't know.
Yeah, it's hard, but it's always making sure you have, one, a good relationship with the prosecutor, and two, that you don't just call them every day. You know, you have to kind of understand the limits that they don't want to hear from you anymore. But you got to poke a little bit every once in a while. Yeah.
We
We had a car, I think that was in, it was in town for like 2 or 3 years. By the time we got it back, it was one.
Yeah.
It was for 2 or 3 years, one more than.
2 or 3 years is a long time.
Yeah, and we were calling every once in a while, they knew we wanted it in our car.
Was anything filed with the court system?
No. Is that a difference?
Yes.
That makes a difference. Okay.
Yeah, they'll get phone calls from everybody, and they'll just tell them what's going on. You have to put something on the docket. Yeah, it's gonna cost you, some money to get the motion out there, but at least it's there, because then you can point to it. Hey, prosecutor, what are you guys doing with our motion? And every once in a while, we had one in Cleveland where we did poke every once in a while, and finally, we had some breakthrough. Like, all right, we really don't need it for evidence, and the prosecutor's gonna put something on the docket. Now we're able to check all the time. And we check, hey, you haven't filed it yet, you haven't filed it yet. Finally, they filed it, and then now we have to push the judge to get the order, or at least get us a hearing. It's that kind of push you need. Phone calls aren't gonna do it to a prosecutor, even to a tow shop. But when you get that motion filed, you can at least, we filed motions to request hearings just to see why this is part of evidence. It's a losing battle, but at least you're in front of the judge saying, we're losing a lot of money here, mine's losing a lot of money, we're gonna do this car. Just get that route. This one's just a little more difficult to deal with. Our vehicle's towed, private property. I'm sure you've seen a lot of this, maybe you haven't. But it's just a standard tow, car's been left overnight. Tow company comes in, now they're storing it at their lot. Now you've got a nice statute, all right? Towing facility has 3 days to search the records for any liens, and then within 5 days has to locate the lien holder and send notice by certified mail, all right? Those two things, I don't want to say never happen, but they rarely happen from an impound law, all right? Before the new law, I want to say the new law was in 2017 or 2018, before the new law, tow companies can charge a reasonable rate for storage, all right? You have to pay the tow, but that's not what you're worried about. You're worried about storage. That storage used to be reasonable, okay? Tow shop ABC says it's $25 a day. Tow shop XYZ says it's $50 a day. Don't even try figuring out what reasonable is. So, there are so many fights within your industry and the tow companies and those lots where they passed a really nice statute and regulation. And within it, they've kept this language on storage and notice. What they added was the amount of the tow shop can recover for storage. Last I checked, I think it was $17 a day. So, okay, that sounds reasonable. If they sent you notice within 5 days and you received it and you're not calling them, you're not getting your car, they're going to get $17 a day for storage. What ends up happening is you do get that notice, you do call, and maybe they don't call you back. The minute you call them, triggers storage, triggers the stoppage of storage. And you can argue, we called, and maybe it's in your system when you call and who you talk to. That's the first day. That's the only day they can charge storage. And we've fought these cases. And you just have to be very quick. Give tow companies or impound lots, whoever you're talking to, give them a couple days, that's it. They're not going to say, come to my lot, bring your whole harmless, bring whatever documents you give a lien, that's fine. But if they're just blowing you off, you gotta press them harder. And that's, again, an unfortunate thing, you make the law firm. In the same sense, you have many more options on this side of things. Yeah.
So are impound lots allowed to refuse taking like full harmless, copy title, RICO order, whatever the paperwork is, and demand like that court order because?
No, if there's no court case.
Okay, so if an impound lot's just being difficult, and they it's one specific one where they want like some kind of order from the court of repossession because we're just building.
Yeah, so that's what, it's knowledge, right? And I hope we pick some of this up today. You can just go back and say there's no court case. And you can say, I have an attorney, we're going to be sending you a letter. The letters we send is by certified mail, it gives them the statute, and it's not good for them. You can get more damages on them than you get a borrower. But they don't know that.
So hypothetically, to get around that, what if we just flip the title?
If they do.
No, you,
If
we
we just flip the big that, like.
to the contract,
anything
wow.
illegal?
I mean, I think you all do that when it's a repo anyways.
Yeah.
I mean, work with them a little bit. before you start doing that, because you want to prove that you're the lien holder if you have to file. So if you're flipping title, I don't think it's a big deal, but keep it as a lien. And again, I know it's hard because you do have to go to an attorney to file something, but you've got them. Mostly when it comes from a phone call from our firm or a letter from the firm, that's all of a sudden when we're like, whoa, where are you getting this from? Why can't we charge $50 a day? Why can't we ask for a court order? If there is a court case, and the lot says, the police said we can't remove this without a court order hold. Okay, let's find a case and let's do that. Otherwise, if there's no court case and it's sitting there, you unfortunately have to file. But there's an option, because now you don't have to pay for any storage. And then you can sue them on top of that. Or more. But we usually catch it by a phone call or a letter. Every once in a while we do the file and go through the court system because the tow shop is living under the 2017 and prior days. And they say, no, we're owed. Okay, you say it's 10 days, but that's still $50 a day. So we give them the statute. They see it's 17. They go to an attorney. Their attorney calls us. How do we negotiate this?
That's
You
the
don't have to.
cap.
I'm sorry?
$17 a day is the cap.
Yeah, it's 17 or 19, somewhere in that range. But yeah, it's under 20.
So anybody charging like 30 or 35 days?
And you can just, and then, again, it's being armed, so it's the statute. Here's the statute. A lot of times when we call tow companies, you can send it an email with it, they probably trash it. So it's really going to be how far and how hard you want to press. I would just say press quickly and get it in your system that you contacted them and that they refused. Contacted, refused, triggers the stopping of the storage. And then you can prove that in court with an affidavit. This is when they were contacted. You gotta stop storage.
What is the statute on the $17 to $19?
I can get that up to you. I'll send you an email with the statutes on this.
Sure.
Yeah, and then we'll set that up.
Okay.
Clear as day. It's right in there.
It's a whole lot better to employees, because a couple of the
Yep.
income lots we deal with up in northern Ohio, they're not the most friendly.
We know that.
Okay, so, I don't know the statute.
Unfortunately, sometimes we see the same name over and over again. But what's nice is they also see our name again over and over. And they're like, not again. So I will tell you, it's kind of strange, but some of them have almost like a ring going on where they know they can send these notices to a lot of creditors, and the creditors just pay.
Yeah.
Right? We've had this car for 50 days. It's $50 a day, and you owe us all this money. And then the creditor's like, oh, okay. Okay. You towed it, you stored it, I get it. No, you shouldn't get it. All right, so as soon as you get this notice, if you ever do, we don't have many clients that actually get this notice. If you get them, act quickly. Yes.
Two things, when they charge a whole bunch for like cleanup fees, this cleanup fee, I mean, they just go on. I've seen that.
Title fee, $250. We have to file for a title, what do you want? After 3 months. you have to file.
Well, did they tow it or did they repair it?
Oh,
Right. So if they towed it, what else are they looking for?
cleanup fees, I think that's an admin fee, and they just recommend.
They don't even get the car out that vehicle.
Talking about like trash cycle.
They look for every business transfer, because, you know, I said, okay, you didn't have to file the title, because you send notice to the lien holder, whoever, and to the lien holder, and 3 notices after that, you can, right, I guess, something like that. So there's no filing for, but in the case of the city, they say how much you owe, how much you charge them. Because they have always have admin fee, title fee.
Well, if there's no title fee, that means they've already flipped the title.
They cannot do that.
Okay,
They're
so.
saying they do, but they're just finding, we know
No,
about.
again.
That's when you call Franco.
You're saying, can they? Of course they can. I mean, anybody can put anything on a piece of paper and say, we're owed this. If you're looking at crash site, so looking at, what you have to figure out is what's that reasonable cost? They're cleaning a car out, no reason to do that. If they're doing anything, they're giving it a car wash, they're coming in and they're fixing the engine. That's not a tow. Now it's a repair shop. By the way, you have consent from the borrower to do that work. So they don't want to hear from attorneys. At the end of the day, they do not want to hear from attorneys. Especially once they give them statutes. Our demand letters give them the statutes, nothing to hide from. Here's what it is. Okay, our client got notice on January 2nd, and you've been storing it for the last few days. Maybe you work with them, you give them a couple days. But that's it, that's it. Again, you're going to have, it's a timing issue, right? Because you want to get that car, you want to start putting it up for sale again. You got to go to the court system. So you're going to be out about 30 or 45 days, but at least you stop the bleeding.
What's the definition of private property?
Anybody's private property.
Not as long as it's not ordered by the police or the sheriff.
Yeah, but nothing that
Say
is.
I park in a bad parking, say I go to Walmart and park in a handicap zone.
Yeah, that's private. So what you're doing is, and you can probably see signs up there, max towing fee, all this stuff. Those are all private areas. When you talk about public, you are really talking about, not public places. All right, we're talking about more like police and anything of a crash scene, anything that you can talk about, investigation of these cars. So it's more on that end, where the police were called for an emergency to go pick this car up. It's not, hey, sheriff, can you go pick up this car at Walmart? No. That's when you call ABC Tow and they pick it up. But a lot, I have to say a lot, a good chunk of them have started to understand the new statute and they know what is required. They just don't want to, right? Because they have to draft a letter up, they got to send out by certified mail. Well, it takes time. Instead, why don't they just send out a letter after 30 days and try to catch you? Like, hey, we've been storing it for 30 days. Well, you haven't been.
I was going to add, I've been doing this for upwards of 20 years from a lender perspective. And I've done my damnedest talking with these people many, many times in the same scenario and not gotten anywhere. And actually had Franco's firm reach out to them via phone or certified mail many times just for your guys' information. And it's just something that it's a little harder coming from an attorney than even somebody that thinks they know what they're talking about. Using Franco's firm, it hits a lot different. He's going to save us lots of money in the same scenario many, many times.
Yeah, I appreciate that, and that is, it's the speed at which you want to do them. I will tell you, we've gotten a lot of these to come back just with a phone call. We've had other lien holders call us and say, can you just call them? Yeah, we'll call them. We give a call, we tell them. Some of them do understand. Some of them quote us the old statute. And that's when you know you've got them. If they know the law, the old law, you got them. Because you give them the new law, and they say, well, we didn't know about this. Yeah, but you always knew about the notice. That's what kills me. Is this notice has been around for decades. That's not the problem. They always want storage. Send a letter. Send a letter. Protect yourself. Actually, almost be representing these guys.
I never received that.
And how many letters do you actually get? None. And some do, and it's so far outside. I mean, they'll store it on January 2nd. You get a letter in March. Or we want 60 days. Or, of course. But yeah, so as far as it comes here, this is, which I know you guys run through a lot, there's ways to stop this. All right, and a tow company knows if you're negotiating in the wrong way, if you're trying to negotiate dollars and cents from them, you're in the wrong field. You only do that for a police tow, not for this tow. But this one, you say, when did you send me that notice? I don't have a copy of it. And then you start working backwards. When did you start storing it? And if they give you a date that's months past, no, you're not getting anything. If it's a really nice car, and they'll say, okay, give us like 20 days. Now you're in the negotiation room. Now you're somewhere. But if it's a low-value car, you got to cut it off somewhere. At the end of the day, we can get money off of these tow companies too. So it's not just against the borrower. We can get money against these guys as well. So just keep that in mind when you're seeing this scenario.
Okay, I have one other question.
Yeah.
That statute for the $17 to $19 a day, does that only apply to the privately towed?
Yes, 100%.
Okay, so if people get pulled over and they don't have insurance, so they have to haul it off, and then they have to tell us, hey, your vehicle is leaking, and someone told the facility, what do you want to get? That's where I gotta go and show proof of ownership.
Yeah, but that's still not going to be a court order hold. That's not going to. You probably won't have as many issues on that. If you still need assistance from an officer, It's who's calling off that car. All right, so you can try. You can try to call a tow company and say, here's the statute. And, this is a reasonable amount. But you have to remember, the sheriff's the one sending that notice. I do have to reread that statute. There might be some discussions on just giving all liability to the tow company. Like the sheriff's not towing this car. So maybe there's some movement there. All right, repair shops. Top line, Ohio, the owner has priority over any claim for payment from a repair shop. Period. All right, so if a repair shop says, we made these repairs, pay us, we won't. No. One issue you're going to have is if they did significant amount of repairs, and now they believe the repair shop has an equitable lien. There's case law behind it. Those are things you need to worry about. You do want to negotiate with the repair shop. If a repair shop took a car and made it better, and you know you're actually going to get more money from it, now you've got room to talk. All right? The law says you have a superior lien. If you have a lien on this car, it is superior. You get a judge in Cleveland that sees these cases. Maybe it takes a little longer for them to realize that this is actually a statute. They don't understand why. Why? Why should a lien order? Well, because one, you didn't know about it. You're not a borrower. You didn't ask for this. But this is usually when you get a borrower that goes into a repair shop. There's the car. They get the bill. They say, "Ooh, nothing." And walk away. Same deal with the repair shop. They want to recover anything storage. Because at that point, they almost become a tow facility and a storage lot. They then, if they want to ask you, hey, we repaired the engine, we fixed the bumper, and we stored it for 90 days. No. They too can send that notice and give you, hey, we got the car here, storage begins tomorrow. Okay, call them, I'm getting this car. If you're negotiating that fee, it doesn't count. You just tell them, that's my car. We're getting this car, here's the amount that it was in tow, and we're charging for that. When it comes to the repairs, it's again critical to act very, very quickly. And you eventually get repair shops that understand it, and they know that they're behind the eight ball. So again, you want to kind of look at that car and say, well, I could probably actually get more money at a sale from this car for the work you did. And that's how you get them. So, look, you did a great job here. We'll give you $1,000. That's all we're going to do. I have to pay an attorney less than that, but they're going to file. Why would we want to do that? But you got to start making some cutoffs and figure out how much is it going to cost an attorney versus how much am I going to pay this repair shop. And you just tell them that. You just tell them that I have to get an attorney for this. Here's what's going to cost me to do it for them. And they're going to be right, by the way. You're going to be wrong. So again, it's a lot of, you need a lot of assistance, but like you mentioned, if you've got the statutes, if you've got the verbiage in front of you, it helps more. They start to say, I'm going to send a statute over.
Are there repercussions if we go in the evening to take that vehicle?
At a repair shop on the outside, the outskirts, if you're a defaulted payment, probably could. Be careful on, you're trespassing even in public areas when you do that with repo. I mean, you go on if you see that car in someone's driveway, you go repo that car. Right? I mean, you're looking about breach of policy. A lot of repair shops have closed their places up, but there's still a lot that are just open lots. I've seen a lot recently, though, that have no cars in the morning. They literally only take repairs that day. When they close up their shop, there's not one single car that's on their lot. I've seen that a lot more lately, and I'm wondering if it's because they're seeing a pickup in repos.
There's no recourse for that, if they just happen to pick up a car randomly that was at a repair shop?
Recourse by you or the
But like any liability for like my company, if my.
damage the parking lot, maybe.
But not for the bills, like that other.
You don't know that.
So the other entity would have to go after the borrower as well.
Yeah, but you know they're going to go after you too. I mean, that's just, it's common. But you have defenses. So there you would be defensive. And on the other side, it's more aggressive where you have to come to the office and say, leave the car on the pay.
They didn't like actually steal anything from like Monday or something that had.
Right now, the car's there. But again, I mean, be careful with, lots that have gates, fences. I'm sorry? Yeah, if you can't get the car, don't get behind the car. Don't get, you can't get, yeah, unless you're gonna somehow look it up.
There's people that do that, I'm not gonna go there.
We don't want to know about that, but yeah, I mean, as far as getting the cars, I mean, you've been in some tough spots where you're getting cars in tough areas. And you do it because you have a right to do it. You cannot breach the peace. That's it. Again, we go back to that first one where you're doing a repleven, let the court breach the peace. All right, so either way, it comes to repairs, no more negotiation, but you do understand that you have a superior lien. You're gonna fight it, and do it quickly. Pursuing deficiency balance, this is for you all that are financing that car, whether you're the dealer that finances or you're the finance company that finances the car. It's deciding on the collectability of a borrower after the vehicle has been repossessed. All right, some things we see that lenders look at, even dealers look at: credit application. Can you verify employment from that borrower? Were they employed before they lost the car? Are they employable? Review of social media. I'm still shocked at the amount of people that have public accounts that post their jobs. Hey, you got a good job, right? You know, if you have debt and somebody's coming after you, you might want to stop doing that. But as far as what we see, they continue to do that. And then, does the borrower own property? All right. As we talk about later on, getting into judgment, once you get a judgment, you can lien on the property, and you can do certain things. So if they own property, that's probably a good way to continue on with a deficiency. So you've repoed the car, you did a quick check on credit apps, social media, if they own property, you say, you know what, this is worth it. You gotta act pretty quickly too. So once it's defaulted, you repoed the car, that second little mail there says, within 5 days of repossession, send out a notice to cure. This notice allows the borrower 20 days from the date of repossession to cure the default. All right, curing. What is it? It's past due payments. It's a towing fee up to $200. Anything above that, you can attach to the back of the loan, and some other charges. All right, they've got 20 days to make that payment. If they do make that payment, and you're out there a week later doing it again, you do not have to send another notice of cure. Once and once only. So that notice gets sent out. A lot of creditors do send